This marks the end of our basic level. Let's have a quick recap. Competition simply means a rivalry to get something, like profits, customers, sales, goodwill, or just market monopoly. Fair competition between businesses means competing on factors like quality, price, and customer support services. So, any act of competition which goes against honest practices in industrial or commercial matters is an act of unfair competition. For example, passing off, trade libel, or even misuse of trade secrets or confidential information. As a general guideline, in order to be confidential, information must be commercially valuable, protected by taking reasonable steps to ensure its confidentiality, communicated to the receiving party in confidence, not in the public domain. It can include know-how as well as trade secrets. In India, we don't have a separate law protecting know-how, trade secrets, or any other confidential information. But remedies for breach of confidence or theft or disclosure of trade secrets are available under contract law as well as common law. Wondering what happens if, despite being marked as confidential, your information is disclosed without authorization? You will have the following remedies, subject to certain factors, in such cases, injunctions and damages. Coming to integrated circuits, semiconductor chip protection. Think of the microchips on your laptop. They are integrated circuits, ICs. The particular way these integrated circuits are arranged is protected in India as a form of IP. Only original, inherently distinctive, and inherently distinguishable layout designs are eligible for protection. The term of protection is 10 years. Another IP variant is the Law on Protection of Plant Varieties. It provides some exclusive rights to breeders of new varieties of plants. The criteria for protection is novelty, distinctiveness, uniformity, and stability. NDUS is a good way to remember that. In India, there are 150 notified registrable crop species. Trees and vines are protected for a period of 9 years, which can be further extended to 18 years. For all other cases, protection is given for 6 years, extendable to 15 years.
Can you please confirm if the screen is visible and I'm audible?
Yes, sir. It is visible and sir, you are audible also.
Okay, great. So, namaskar and good afternoon to all. It's a great pleasure and privilege to welcome you all today for L2 Pro workshop on trade secrets. Just one second. On trade secrets across borders, legal standards and enforcement challenges for startups and MSMEs around trade secrets. I'm your host, Nitin Sharma. I work for Qualcomm's Technology Council, looking after various IP initiatives at Qualcomm India. This is the webinar series that we have started to connect with you all in the field of intellectual property. Now, we all know this is the field, this is the century of intellectual property. And for any country which aims to play a significant role in global economy, intellectual property plays a crucial role in achieving that goal. No matter what industry it is, innovation and protecting the innovation is the key to drive the maximum value of any industry that you are in. Through this webinar series and L2 Pro platform, our goal is to spread awareness around IPR. Now, today's webinar is a very interesting one where we'll hear insights around trade secrets and across the borders, and we'll look at the legal standards and enforcement challenges in this. When I interact with startups, I really find the lack of knowledge around how do you manage trade secrets. I think over a period of time, the ecosystem has learned reasonably well around patents, right? Trademarks were always well understood, copyrights to a certain extent, patents we're getting there. But I feel like trade secrets are still the topic wherein a lot of startups and MSMEs, especially these small companies, are not really clear on how to manage it. And How do you ensure that your information is shared with the partners or vendors at the same time? How do you protect it, right? So we'll hear some of those challenges, some of those approaches, etc., in a short while. And we'll have two great speakers, which I'll introduce in a short while. But before that, I would like to take a brief, I'd like to talk briefly about the IP course material called L2 Pro. So this series is brought to you by L2 Pro, which stands for Learn to Protect, Secure, and Maximize Your Innovation. Now, we've been working with startups through Qualcomm Design India Challenge program, etc., and various other initiatives. And what we've found is there are certain startups who are reasonably well versed with IP and how to use IP for maximizing the value of their businesses. But there are other startups which really need handholding in preparing a good IP strategy that's aligned with their businesses, etc. This understanding led us to create this platform called L2 Pro, which is a partnership between DPIIT, CPAM, and NLU Delhi, and Qualcomm, wherein we all came together and created this platform, which is basically going to provide help in increasing awareness and in help in better understanding of the IP concepts, right? Things that we want to cover in this platform is how do you protect your innovations with patents? How do you use copyrights? How do you develop or build your trademarks? Integrate your IP related considerations into the business strategy and models, right? Because that's very important. It's IP strategy cannot be a standalone strategy, right? So it has to be integrated with your other strategies and overall company's vision. How do you obtain value from your R&D, right? And finally, how do we enable innovators to access tools which are available through the Government of India initiatives or elsewhere to protect their innovations and go quickly to the market? Now, this platform has three modules, right? Basically, the basic one is about fundamentals, right? So in this, we talk about introduction to patents, trademarks, and geographical indications, and all other forms of IP protection, right? We do cover some of the topics around unfair competition and therefore trade secrets and basically give a good overview of what kind of protection is available. Then we move on to the intermediate level, wherein we talk about non-disclosure agreements and restricted covenants, etc. Talk about the procedures to file IP and commercialize IP and so on and so forth. Then we move on to the advanced level, wherein we talk about funding, venture capital access, etc. We also have a module on standards and standard setting organization so that you get familiarized with some of these concepts and potentially move to standard essential patterns related concepts as well. And finally, we also have some insight into managing disputes, infringement, validity, etc. Now, this app is available, or this course is available in two modes, right? One is a website, which is called as l2proindia.com, which was mentioned at this slide, and it's also available as a mobile app on Android Play Store. So you see certain screenshots here, which are taken from the app. Very rich content, and basically it has certain introductory videos before every topic so that you get an overview of the topic before you start going through the content. And once you go through the content, you basically have certain questions that pop up to understand your learning as you go along, right? And finally, it has a certificate. If you complete the modules, you get the certificate, which is certified by CPAM, NLU Delhi, Qualcomm, and DPIIT. So very well, spent. I mean, it's a very well good use of your time and to get a good understanding of it. So I hope you will basically use this platform to build your understanding and get a foundation from where you can build a good IP strategy. Okay, so with that, let me move on to our next segment. And I would like to introduce our first distinguished speaker, Sri Mohammad Faisal, who is General Manager and Global IPR Head for Tata Motors Group. Mohammad Faisal is working as General Manager and Global IPR Head for Tata Motors Group. He is listed among top IP professionals, including IM Strategy 300, and has over 22 years of experience in IPR domain across various industries. Before joining Tata Motors, he has worked with leading technology conglomerate, L&T Technology Services, and reputed law firms such as LexOrbis and Singhania and Company. Faisal possesses more than 2 decades of experience in innovation lifecycle management, IP procurement, etc. It's an honor and privilege to welcome you, Faisal. Over to you, and we'd love to hear your thoughts on this wonderful topic that we have, and not so much understood. So, really looking forward to it. So, over to you.
Thank you, Nitin. It was wonderful to know this about this course, L2 Pro. I think it's an hour. It's a need of an hour of the hour. Various courses are available online and offline, but the content is something which often is not sufficient for the learners, especially for the beginners. I'm looking forward to have a look at the courses which you have just talked about, and would love to see what kind of content you have put across. I'm
Please,
sure it is.
Share your feedback once you have it, and we can see how we can improve. Thank you.
Sure. So, thank you for inviting me here. As you said, my experience largely is in patents, and trade secret is a part of the profession, being the head of IPR department, and it comes on and off. Firstly, secondly is my experience is largely in engineering sector. Different roles, different companies. L&T has almost all engineering sector. From last 4 years, I was associated with Tata Motors, which is majorly in automotive domain. But these companies also have a share bit of challenges in terms of handling their trade secrets. So I would put up a presentation. Would you like to introduce the other speaker, or should I go ahead and start sharing the content?
Yeah, I think you can start, and then we move on to the next segment, and we can introduce.
Sure. So I will share my screen and put up the presentation. Just give me a minute. Do let me know once you are able to see the content.
Yeah, we can see the mode. Yeah, we can see the slide mode now. Yes.
Okay. Perfect. So Nitin has already provided a brief introduction about what trade secret is. Let me begin with what constitute trade secrets. What is, often it's an ambiguity and understanding whether a particular piece of information constitute information as trade secret or not. Now, first of all, the what is constituted as a trade secret should qualify for an information which is not generally available to the public. If you have put a content on your website, if you have put an information in public domain, if you had been talking about it in public forums, then that typically do not constitute a trade secret, because that information you have already let out in the public forum, in the public domain. So an information to qualify as a trade secret, the first and at most requirement for it is that it should not be available to public in general, or it should not be available as part of information which is out there somewhere, which may be a traditional knowledge or something which is already accessible through some means to the public in general. Second important aspect is that the information which we are talking about should add some commercial advantage. Like, for example, if you have a means of calculating something, and that calculation is which determines um, the the value of your product, and that the method in which you are determining the commercial value of that product has certain novelty in it, then it could be that is if it gets leaks, then other will also start using it and start using the same way to calculate the output of their product. Then it will have a commercial worth in it. But a knowledge or information which do not impart any commercial worth, whether to the processes, whether to the product itself, or whether the way in which you are doing or putting up the business in public, then again it may not constitute a commercial, it may not constitute a trade secret per se. Many times the people start qualifying each and every information which they have as trade secret. So this is one of the important factor which determines whether a particular piece of information you can qualify as trade secret or not. Courts largely look at this specific aspect, that what is the loss your organization will have if this piece of information is passes on to your competitor or to the public in general. What is the commercial loss your organization will face? Is the greater determination or determinant in determining whether a piece of information constitute as a trade secret or not. Next is that you should do reasonable measures. You should take reasonable measures to keep the information protected. It's not that you have a piece of information, it got leaked, and then tomorrow you say that that my trade secrets are stolen or leaked, but you have not put any reasonable measures such as keeping it secure within your organization. Or for example, if it's accessible to multiple people, then you have not constituted a legal agreement with those people to keep it secret. Or for example, if you have been talking about it in public, so unless you have done some reasonable protection measures to keep the information secret, it may lead to a piece of information not qualify as trade secret. What are the examples? The examples are formulas, algorithms, source codes, client list. This could be also a trade secret. The information in which how you what are the components are included in your product. A classical example is Coca-Cola, which talks about how they have kept the formula secret for their product, and so on. So this is what defines whether the information that you have constitute trade secret or not. Now moving on, why trade secret? Why the trade secrets are required? Why this information? Why can't you protect it under patents? What is the value you're going to get out of it? So first of all is that once you release or once you put information in public domain, even if it is protected by the best possible protection out there is patents. The patent protection is available for 20 years. After 20 years, the information became public. So if you feel that the information that you have, or the secret which you are holding, or the component of the technology that you are holding back, it's not possible for anyone to reverse engineering it, and you can keep that information secret for more than 20 years, then why not extend the protection beyond 20 years? Once you file the patent, you are disclosing your information in the public domain, and that information anyway will become public after 20 years. Second is that patent is a territorial right. So you have, if you wanted to protect globally, then you have to file application in all those countries, which is very costly. Um, whereas um, trade secret, if you are not doing business in a particular country, you may not like to protect your idea in that country. However, your information, if you filed a patent, it will be available to people throughout the globe, because the applications which got published, it's accessible across the globe through internet. So if you want to keep your information uh, safe for a longer period, and you see that it is not possible for anyone to reverse engineer it or to develop the information by looking at your product without getting that information from you, then the trade secret could be one of the wonderful means for protecting, so providing protection around it. Of course, you have to do the reasonable steps. Like, for example, you have to ensure that the access to that technology or that information is restricted. Even if you provide the access to that information, then you provide proper legal means in place, like, for example, non-disclosure agreements, contracts, uh, terms and conditions under which uh, the information can be shared. Even if they are your employees, you need to create the proper legal documentation to ensure that once the employee or once the person leaves the company, they should not disclose that kind of information to a competitor, to anyone else outside the organization. The economical worth in such kind of cases is very high. Uh, of course, since it is not a patent, you can't do the valuation on the patent basis, but it's possible to do the valuation of trade secrets also. There are means, there are ways in which you can identify and do the valuation, and it can be treated like any other IP. If the only thing which you need to show is that there are reasonable steps or measures to ensure that protection is around the secret in place. As I was saying, that the Coca-Cola is one of the most talked about case studies when it comes to trade secret. They are in business for more than 135 years now. Uh, their exact formula is still, people don't know. One of the reasons for that is that they keep on changing the formula in bits and pieces. Once they feel that people have identified the formula to a reasonable extent, then they keep on changing, and then that's how they keep on uh, improving on the formula, and then they keep on protecting it. Now, how they did it is that they have they have multiple measures which they have put in place to provide restricted access, to make sure that the ingredients are mixed at a specific unit only, and then distributed from centrally from the single place. Even if the ingredients are supplied, then they are not supplied from a single location, or the different ingredients are supplied from different locations, so that it's not easy for anybody to identify the ingredient itself. They have very strong contracts with their suppliers, with the people who are engaged in that process, and any breach of it would have resulted into a huge commercial penalties for the people who are involved in that process. And so that's how they were able to keep their formula safeguarded over the hundreds of years. Had it been a patent protection for their formula, it would have lost it in 20 years at max, and then it would have become a public property and everybody would have started using it. I'm not saying that that means that we should not file patents, but what I'm trying to tell you here is that if you feel that your technology life is beyond 20 years, then trade secret could be one of the possible kind of protection which we can think about before approaching or before going ahead for patent filing. Now, in India specific landscape, Nitin had already talked about that there's no standalone trade secret agreement that we have. It is typically protected through Contract, Equity, and IT Act in India. So the absence of Trade Secret Act does not mean that courts have not recognized trade secrets in India. There had been multiple cases. There had been multiple. We have enough jurisprudence in where courts have determined that trade secrets are a form of intellectual property, and they had even given the compensation to the companies where the trade secrets are misappropriately stolen from the companies. One of the important aspects of trade secret is that how in many cases it so happened that trade secret was disclosed by the employees when once they have left the organization, moved typically to the competitor, and they fail to understand that they have a they have a uh, they have a they have a restriction on disclosing the information even post employment with a company. Typically in most companies, when we sign the employment agreement, we have this clauses which talks about that you have to maintain the confidentiality even if you leave the organization. And many organizations these days also ask you to sign a non-disclosure agreement at the time of leaving the organization, so that you should ensure that any information which you have came across during the employment, you will not disclose at least for certain years post you leave the employment. Now, what kind of remedies or what kind of reliefs are available? So there are criminal as well as financial. Both type of reliefs are available. Criminal overlaps are under IPC and IT Act for data theft, and similarly, financial reliefs are also available. As I was talking earlier, that the enforcement or the determination of the trade secret is largely depends on the contracts and the contractual obligations around it. One has to show that somebody has taken that information under a contract and then they misused it. That is the basis for most of the uh, case laws which happened in the trade secret domain. If somebody can prove that they have got the access to the information without or getting engaged with the organization, or if they can they can establish that they themselves were able to use that information by looking at the product, by doing experimentation and so on, but they have not taken any they were not under any direct contractual employment uh, with that organization, or they have not taken that information from a person who is under direct contractual employment of that organization, then it's then the trade secret uh, uh, they may not fall under the purview of trade secret jurisdiction, or they would not be liable for the breach here. One of the case studies from Indian jurisprudence is Infosys versus with one of their employees, where the one employee has left the organization and took a part of their software and handed over to one of their competitors. That Infosys filed a case against the employee. It was the court evaluated it and then recognized that proprietary software was indeed taken by that employee and it was misused, and they had given the relief to the Infosys. Now, we also talked about cross-border enforcement challenges. Trade secret, as we were talking about, that there are no specific laws which govern the trade secret in India, and so is in most of the countries outside India. Very few countries do have defined laws and acts which talks about how the trade secret can be governed, but most of the countries do not have any specific laws which determine how the trade secrets should be governed. Like in uh, unlike patents, where there's almost harmony across the globe, how the patents will be handled, the trade secret do not enjoy that kind of monopoly. Different countries employ different laws. Like in India, it's generally determined under contract law. Similarly, in many other countries, it depends on their specific jurisdictions and case laws. The one the most important challenge that we face when we have to deal with cross-border trade secret is that the choice of law. For example, if we are dealing between two countries, we can file case in either of these two countries. But where we are going to file is itself is a uh, concern. I'm sure my friend who is from legal firm would throw more light on it. I would not like to talk too much about the legal aspect of it. But selection of jurisdiction itself is a challenge. Then, um, you know, how the laws are determined in different countries. What are the definitions? What are the definitions which constitute contractual obligations? What are the definitions which determine what is breach of contract? And so on, varies from countries to country. And again, it may be an issue. Another aspect is the litigation cost. If you wanted to go for a litigation, if you choose an arbitration, that also comes at a cost. If it's within the within the country, then the cost itself is substantial. But when different countries are involved, the legal cost shoots like anything. Evidences also plays an important role, where one of the challenges is that how you have protected the evidences or how you have procured the evidences. That itself may vary from country to country. What is constituted as a proper evidence may vary from one country to another country, and that may pose a challenge when it comes to trade secret um, litigation. Employment laws also may come as a challenge, because many countries have specific employment laws, and when it comes to movement of people, when it comes to a person is moved working in India and that person moves abroad and have taken a particular set of information with them, then how the foreign country will treat that employee will depend on the laws in which that person is working. Unless you wanted to file a case in India, but then again the challenge would be the employees outside India. Customs can play an important role, and then they can provide remedies um, in terms of intangible assets. But then again, customs work based on the decisions or the directions of the court, and that has to be secured before. One of the case studies from US is Kevlar fiber trades. Kevlar fibers between where one of their employee stolen their secret and joined their competitor company and hand over their secrets to the competitor company, DuPont. Kevlar filed a case against them. A verdict was granted, and they eventually settled for $275 million. So employees are one of the key aspect where which causes the leakage of trade secret, and this case study shows that it's very important to have a very very well defined employment agreement with the employees to make sure that once they leave the organization, any information which they are taking and which can constitute as a trade secret should not be handed over to the competitor or any other company in general. So how will you do the safeguard for your trade secrets, particularly for startups and MSMEs? That it's important that you keep a tag around your secrets. You mark them that this is a trade secret information. You provide a safe position location for it. You can keep a register or you can mark it confidential. Many times the emails that we send, we forget to mark it's confidential information or something like that, and that may result into breach of contract, or somebody can prove that this information was shared without indicating that this confidential information, and hence it's a public knowledge, and it we presume that this is a public knowledge and hence we used it. So it's important to tag and identify what is the confidential information in your organization, mark it, keep it secure at a place which has a limited access to the people. You should have strong contracts, non-disclosure agreement, confidentialities, IP assignments. These are the specific types of contracts and agreements which we can do with the people with whom we are sharing information. Typically for startups, many times it so happens that they are so excited about the products that they have, they start talking about it in various forums without creating a legal obligations between the people, or they start sharing the information about their product with multiple companies without creating a non-disclosure agreement or confidentiality agreement with those organizations. That may lead to leakage of the trade secret. When you define and when you catalog the trade secret information, you provide limited access to it. Only the people who need it or who require it should be allowed access to it. Within the organization, free access to each and every of information may lead to the leakage of trade secret. So it's important to have a proper IT network where whatever information you are having is shared with the people on need to know basis and who are actually required to use that information. I talked about it earlier. Employees onboarding, offboarding processes are very important. If we have a process, if we don't have a proper contracts or agreement with the employees, it may lead to the breach of trade secrets at a later date. Whether an employee is allowed to share the information which they have learned during the organization will depend on these employees' agreement. So it's very important to craft them. You should have proper legal vetted employee agreement, thought it through from multiple aspects, and one of the key aspects is employee leakage of trade secret. Then it is also important that you should create awareness about the secret information that you have in the organization to your employees. Appraise them that they are under legal obligations not to disclose either during the employment or after leaving the organization the information which they have acquired while working in the organization. Last is evidence preservation. Now, if we have shared information, like for example, if we have shared the information through an email, or when we share the information with a particular employee through email, and we have a proper confidential information, agreement signed with that particular employee, then this can become a piece of evidence if tomorrow that information is leaked from that employee outside. But if we don't have an evidence to showcase that we have shared that information, or the organization has shared that organization to this particular employee, or if the employee don't have access to a secure system and still the employee is able to get that information somehow, then it becomes very difficult to showcase or to establish that how that piece of information was this employee was able to achieve it. So it's important to create to preserve the evidences. Many times what happens is that we don't create a backup of the transactions that we have. Creating these backups is one of the key to determine or for creating these kind of evidences in place. So what are the enforcement strategies? As I was talking earlier, the most important aspect is to have a strong contractual obligations. If you don't have strong legal documentation around it, if you're in a hurry, you miss that, okay, it doesn't matter, let's share the information, we will have the contracts later. That is not the right strategy. Even if it's taking time, even if the legal is asking too many questions, it's important to have the right contracts, right terms and conditions in place before you share the information. In case there's a breach, then arbitration is one of the key ways in which you can resolve the issues. If you are not able to get relief from arbitration, then you can approach the rightful courts and get a relief there. It's important that if you identify that there is a breach, please involve the legal professionals rather than determining yourself to brainstorm whether there could be a breach or not a breach. And particularly if it involves multiple jurisdictions, then it's important to hire a local counsel or in the country where you are talking about before taking a decision whether you should file a case against for it or not, or which countries you want to file, what could be the best course of action which you can take to get the relief, and so on. Customs and trade may be one of the remedies which you can use to stop organizations or the companies which have wrongfully obtained the information from you. Criminal routes are also available, but in which is typically faster. In many cases, if you want to stop someone from using the information which you have which has been stolen from your organization. And the most important is that you should have the proper technical setup within the organization. For example, if typically the small organizations don't have very strong IT security net system. Many times the access are available to multiple people. Many times they don't have a proper way in which they can trace back the the steps in which information is passed from one person to another person. So these kind of things which is required for particularly for MSMEs and startups to ensure that the IT system which they have they should integrate proper IT setup, IT security. The access to the people is given on need to know basis, and it should be backed by a technical processes. So this is the last slide. So what are the key takeaways? Is that trade secret can last indefinitely if secrecy is preserved, but if secrecy is leaked, then you will lose all the protection around it. It will become a public knowledge, and anybody would be allowed to use that information without any contractual obligation. Contracts are critical in India, particularly because there's no specific statute with respect to trade secrets. But in other countries also, contract plays a very important role in determining or in safeguarding the trade secrets. MSMEs must focus on low-cost preventive safeguards, but not having any safeguards will put you at a higher risk. Enforcement abroad depends on the contracts, and again, when it's depend when it's multi-country contracts, it's important to take at least some guidance from the from a local council from the foreign country also before finalizing the contractual obligations. Document reasonable measures to strengthen legal position. Uh, to, so the documents uh, are the most important piece which determine the protection around the trade secrets. So it's important to create the proper documentation, keep them safeguarded. Uh, Once you sign the contract, keep it in a safe location, um, either online or offline. But if you don't have a contract document per se, then itself you will not be able to enforce it. With that, I will stop. I hope I was able to share insights about topic. Over to you.
Thank you. I think very nice examples. I think really like the practical example, real life examples in terms of employees taking away some of the useful information, etc. I think this is very, very common scenario. And I think in the startup world, this is all the more important because we have seen some instances wherein the partners fall out, they don't, gel well, and one person taking away the stuff and, starting on its own. So I think very, very relevant. Thank you again for this very relevant information. Moving on, our second distinguished, we'll take questions in the end for both the speakers. So we'll move on to our next segment. Second distinguished speaker, Sri Satyam Rathorji, who is Senior Associate KNS Partners. Satyam has been practicing law since 2018, and he handles disputes pertaining to technology, intellectual property before various courts and tribunals. He also handles IP litigation outside India for Indian clients and liaisons with foreign associates for the speedy and effective education of the same. He serves and he advises clients regarding matters related to IPR, including licensing, commercialization, intellectual property, biodiversity, etc. He also handles drafting and vetting of contracts and allied legal documents such as privacy policies, IP policies, confidentiality, and non-disclosure agreements. And he's a regular speaker at various IP fora and seminars organized by leading industry bodies and academic industry. It's an honor and privilege to have you, Satyam. I hand it over to you for your perspective from a lawyer and a legal professional, and how do you see some of these issues that trade secret domain faces, and a few things which Mohammed has also highlighted. So over to you.
Thanks, Nitin and Faisal for the wonderful insight. I'll just share my screen.
Meanwhile, I'll just tell the participants to type your questions in the chat window, and we'll take once we have heard Satyam again. Then you can post questions to either of the panelists.
Yeah, is the screen visible to everyone?
Yes, please go ahead.
Yes.
Maybe you can just put it to the slideshow mode. I see it's in a slide sorter mode. So
Okay. Are the slides changing for you?
no, I think I only see the slide in with the left menu. Yeah, now I see the changing, but it will be better if you could put it in the presentation mode.
Yes. So I've put it in the presentation mode. Are the slides changing on the display?
No, okay, so maybe that mode is not shared. That goes to a separate screen. So
Okay, I'll retry sharing in just a second. Yeah. Are the slides changing now?
It's the same. Maybe
Or
we can
there's some
maximize this
issue?
and start. I think let's just continue. I can maximize this and
Yes. So moving on from, and I'll try to expand on what Faisal has explained to us. Now, as we all know what trade secrets are, so I wanted to highlight, the key issue which most of us face when we come to the identification of trade secret, right? So we also use the term confidential information. So we'll try to look into what is the difference between trade secrets and confidential information. Are confidential information and trade secrets the same stuff, or are they two different things altogether? So as I've tried to explain on the screen, so trade secrets are a kind of a subset of confidential information. A lot of information for you can be confidential in nature, but not all confidential information are trade secrets. As was pointed out in the previous presentation also, what sets trade secrets apart from the rest of the kind of confidential information, that is, the commercial and competitive value or the edge which trade secrets provide to the such type of confidential information, right? So basically, confidential information can be any information which is disclosed by one party to the other, and with the condition that it should not be disclosed to anyone in the public, right? So that the general the kind of secrecy has to be followed for those kind of information. It may or may not have commercial value, but when it comes to trade secret, it is a kind of a confidential information which has a commercial value or a competitive edge. For example, confidential information can be, discussions around or notes around your internal business meetings, right? So those documentations are something which are can be confidential in nature. You must not disclose it out to the public. But such information may not have commercial value. But when it comes to trade secrets, for example, your formulation for any specific product or process in relation to manufacturing of certain components or product at your establishment, so information about that can have commercial value, right? So that should not be disclosed out in the public. So that's the key distinction between confidential information and trade secrets. So it means that all trade secrets are confidential information, but not all confidential informations are trade secrets. Now, as pointed out previously, how do we identify trade secrets? So trade secret is something which is commercially valuable, and it must be known to a limited group of persons under an obligation of confidentiality. And there must be some steps which should have been taken by the holder of the trade secret to keep it secret, right? So let's say if you have a kind of a trade secret in the form of a formula, right? For certain let's take Coca-Cola as example. So they have a formula for their drink, right? Now, if let's say if they keep it secret, right, and they didn't take adequate steps, as Faisal was pointed out, number of steps which they take to ensure the secrecy. If they had not taken those kind of steps, then in that case, if the information was leaked out in the public and they had not taken sufficient steps to protect it, then in that case, it would have been difficult for them to, go to the court and take adequate remedies from the court. So in order for any information to qualify as a trade secret, it has to be commercially valuable. It must be known to a limited group of person on a need to know basis with an obligation of confidentiality. And it must be subject to reasonable steps for its protection as a secret information. Now, coming to India, in India, we don't have any legislation to protect trade secret, unlike other IPR, yeah, other forms of IPR. For example, patent for regulation and protection of patents in India, we have the Patent Act. For trademark, there is a statute, Trademark Act for designs. Same way for copyright, plant varieties, but not for trade secrets. Although attempts have been made in the past. In 2008, we had a trade secret protection bill. Very recently, last year, we had this trade secret protection bill which was circulated, but as of now the status is that we don't have a dedicated legislation for trade secret protection, right? For example, in Trademark Act, you have a specific provision. Okay, if there is an infringement of trademark, under Section 29 of the Trademarks Act, you can go ahead and file a suit for infringement. But that's not the case with trade secret. Now then, how are trade secrets to be protected? If there is no legal statute or a basis for protection, how should we protect it? Now, there are two forms of protection which can be conferred upon trade secret. First is your contractual protection. Trade secret can be protected through enforcement of contractual obligations. Other remedy can be your common law remedy. Remedy, for example, remedy under equity for breach of a confidentiality, that can be used, and judicial precedents are there, and common law remedies for for protection of trade secrets are something which has been recognized by the Indian courts in plethora of judgments. Now, what do you mean by contractual protection? So, as you would recall, as Faisal had pointed out in the last session, that when it comes to sharing of confidential information on a trade secret, how do you share it with a third party? You share it under a non-disclosure agreement. You sign a non-disclosure agreement whereby you lay down the obligation that the third party with whom you're sharing that particular information or trade secret, they have to maintain a standard of protection or secrecy for that trade secret, right? If not a separate NDA, then let's say you have your employees at your company, and they need to know certain trade secret information in order to perform their duties at your company. And in that case, their employment agreement may have suitable model clauses for protection for maintenance of confidentiality of any confidential information or trade secrets which is shared with them. Now, if they go ahead and kind of leak that information out, you can sue them for breach of contractual obligations, right? And then hence the Contracts Act is something which will guide you in terms of protection. Let's say there is no contract, then what will happen in such scenario? So in that case also, Indian courts have held that even in certain cases wherein there was no contractual arrangement while at the time of sharing of the trade secret, still the person with whom that particular form of a trade secret was shared with, under an assumed duty of confidence, in that case, even in the absence of any written contractual arrangement, that person was under an obligation to maintain confidentiality, and henceforth remedies are granted against them. So this is a basic overview of legal landscape in India as far as protection of trade secrets are concerned. Now, as I told you, we have contractual protection for breach of contract. As we discussed, we can go ahead and sue the other party for breach of trade secret or information. Then we have common law remedies under equity, even in the absence of any written contract. You can, if the person had a duty to maintain confidentiality, you can go ahead and file an action against them. Then under the criminal law, under the IPC also, there are certain provisions which says that for criminal breach of trust, or sharing or leakage of information, the criminal law also provide remedies for that. Under IT Act also, if certain information or trade secrets are are stored in an electronic form, in that case, if that is something that is leaked out in public, right, without due authorization, then the IT Act also lays down provisions for remedies in such cases. Now, certain notable cases I have brought it here, and I have mentioned the key rulings which were there in these particular cases, and these are some of the landmark cases as far as trade secrets are concerned. The first case, the Bombay Dyeing Manufacturing versus Meher Karan Singh, as I was talking about, that in the absence of contract also, the other party with whom the confidential information is shared, they have an obligation to maintain confidentiality. And this is something which was reiterated in this particular case. In this case, the court held that the officers, including the defendants, who knew of this particular software was the trade secret, even without an express clause in their employment agreement or in the employee's code of ethics, were enjoined not to part with this information to any third party. So the court basically held that even in the absence of any written agreement to maintain confidentiality, the employees are not allowed to, without due authorization, put this information out in the public domain. In the similar manner, in the second case, that is Anil Gupta versus and Kunal Gupta and G Telefilms versus Sundilal Communication Private Limited. In these cases also, the similar stance was reiterated by the court that even in the absence of any written agreement between the parties, the confidential information or trade secret need to be protected by invoking common law remedy of breach of confidence. Now, the scope of trade secrets have also been highlighted by the court and interpreted by the court. In the first case of Ambience India Private Limited versus Sri Naveen Jain, it was a landmark case in which the ruling was by the Delhi High Court. In this, the court held that a trade secret is protected confidential information which the employees acquire during the course of employment and which should not reach in others in the interest of the employee. Now, also the court made a distinction between what will be considered as a trade secret, what won't be the trade secret. The court held that routine day-to-day affairs of the employer, which can be in the knowledge of the public, right? They cannot be deemed to be trade secret. So you cannot deem each and every information or whatever is happening in your organization as a trade secret. Information which are in the knowledge of many people and are likely to be in the knowledge of people, that they cannot be termed as a trade secret, right? The basic yardstick has to be followed that for any trade secret, it must not be known to the others in the field, and it must have commercial value to it. The court also has, in another case, Fairfist Media versus IT Group. In this case, the court held that a lot of business information, for example, costing, pricing, any strategic details around projected capital investment strategies, customer list, all these information can be deemed to be trade secret because somewhere down the line, these information may add to the competitive advantage or competitive edge of the company or the owner of the trade secret. So all sort of information like these can be termed as trade secrets. Now, what cannot be there within the scope of trade secret or CI? Now, these are the exclusions which the courts generally have held that these cannot be trade secret. Firstly, information that is already there in the public domain, right? Now, the information that is widely practiced, that is widely or commonly used in the market, and information that is very freely available. So all such information cannot be deemed to be confidential information, and even if you're marking these as confidential information somehow as a routine, this may not attract protection from the court of law. Now, in terms of exclusion, the judicial precedents are there. For example, in the first case of Emergent Genetics India Private Limited, the Delhi High Court held that any information or techniques which are not unique or novel, but if they are merely a documentation or compilation of existing material, existing techniques which are freely available or widely practiced, then it will not attract any form of protection under trade secret law or confidentiality. For example, mere rearrangement of a matter, right, that of any information, that cannot be termed to be a kind of a trade secret. For example, any detail which is already available in the public domain, a very common detail, and you try to arrange it in a particular fashion, in a particular framework. Even then, since the information is already there in the public domain, howsoever you do the packaging, that won't amount to a trade secret. Now, similarly, as we pointed out in the earlier in this case, the other case also, there are information which may not be available as trade secrets, and what the court held in this second case was that in any establishment or a company, there can be a lot of matters, right? Any employee who's working in the company may come across a lot of matter. Financial matters would be there, technical production related matters would be there. So not all matters would be can be considered as a trade secret, right? So it's very important then that while we are identifying or while we are signing or framing any documentation, agreements, or NTAs, it is very important that there are adequate information in those agreements which with regard to your identification of trade secret. So it must not be used, the term trade secret must not be used in these agreements in a very, very broad or a vague term, right? There should be a clear-cut definition or a full stop so that the trade secret can be easily identifiable. Okay, these informations can be trade secrets. Now, the courts have also held that, let's say if there is an employee working in your company, and during the course of employments, they learn certain skills, right? Certain way of performing certain activities, or let's say if you are your company is into R&D, right? It's a certain way of conducting research, right? So now those kind of information, let's say if you're there in a company for more than 5, 10 years of experience, so you in that particular professional experience, you learn a lot of things, right? So those kind of skills which are which are onboarded by that particular person will not amount to your trade secret. With the courts have repeatedly held that this is something which cannot be termed as a trade secret. Same thing as far as exclusion is concerned. Bombay High Court also in this case held that not every information or general knowledge of facts can be labeled as a trade secret or confidential information. Any merely by using on your documents, if you are merely using, okay, this is strategy or policy decision or crucial policies repeatedly in a particular document, would not lend a character of secrecy to such document. To lend a character of secrecy to any document or any information, the criteria have to be fulfilled, which have been repeatedly held earlier by the courts. That is, the information must be secret, it must have confidential, it must have commercial value or competitive edge, and the third is that steps should have been taken to protect that information as a trade secret, right? The court also held in this case that any skills that a person acquires during the course of employment cannot be protected under the garb of trade secret. So let's say if there is a doctor who's working in a particular hospital and he has acquired skills about how to do surgery, right? Then, and he has been there in that organization for, let's say, 20 to 25 years, and he learns the best mechanism to perform surgeries. Now, that is, if he goes out and joins another hospital, the previous hospital cannot restrain him from performing surgery, right? Because that's the skill which he has attained. So skills which a person attains, an employee attains, cannot be termed as a trade secret by the employers. Now, as we discussed initially, was that the contractual remedies are there when it comes to protection of trade secrets. If you enter into agreements, specifically when it comes to employer-employee relationships, right? So at the time of your joining any organization, an employee will enter into an employment agreement or confidentiality or non-disclosure agreement based upon the practice of the company. So in those in in these agreements, generally what we see is that while, let's say, the contractual obligations there, and a lot of contractual obligation, representation, and warranties are there, but when and they are for the term of the contract. Let's say the term of the contract mentioned in the contract is for 10 years, then in that case all these obligations of both the parties will be there for those 10 years during the term of the contract. But when it comes to confidentiality obligations, we see that a lot of agreements there, it says that even after the end of the contract between the parties, those obligations will survive. Now, what happens is that there is a specific provision, that is Section 27 of the Contract Act. This section says that any kind of restriction in any contract with regard to profession, right, stopping a employee from going out and joining another company or another entity or organization, if a contract tries to stop that particular employee from opting for that option, that is something which will make the contract void. But the courts have held that even though the any contract provides for a restriction on putting out the confidential information into the public domain after the term of the contract, the courts have repeatedly held that this particular clause will not be in contradiction with section 27 of the contract time. That means even after your employment with a particular employer has ended, you can still be restrained from disclosing the confidential information or trade secrets to the public. So the confidentiality obligation can be there for perpetuity. Okay, this is the position in the common law, as we discussed, that the even in the absence of any written agreement for protection of confidentiality of trade secrets, under the common law, trade secrets are to be protected in such cases of absence of written contract between the parties. Now, these are the cases. This is one case from the Delhi High Court, John Richard Brady versus Chemical Process Equipment Private Limited. Now, the subject matter of this particular suit was about the know-how, information, drawings, and other details in relation to plaintiff's product. So they had a folder production unit. So all the details around it, secret information and drawings, designs, these were there, and these were termed as trade secrets. Now, what the plaintiffs alleged and in the suit was that the machine which was produced by the other party, that is the defendants, it was entirely based on disclosures which were made by the plaintiff to the defendant. So the plaintiff had disclosed information about their fodder production unit to the defendant, and what the plaintiffs were alleging was that the defendant misappropriated those secret information which was given to them, and manufacture a similar kind of a product using that information, and it kind of gave the defendants an unauthorized competitive edge. Now, the defendants, they submitted to the court that there was no written agreement between the parties regarding the maintenance of confidentiality, right? Hence, these information or utilization of that information by the defendant won't amount to breach of confidence. But the court held that these information were provided to the defendant under confidentiality, right? And they were under the duty of an obligation even if there was no contract, and hence that would amount to breach of confidence. Similarly, in other cases also, Delhi High Court and Bombay High Court have held that even in the absence of contract, the confidentiality around trade secrets need to be protected. Now, coming to the last portion of my presentation, what are the best practices one should utilize or adhere to in order to maintain, to keep and maintain the secrecy around their trade secret? Do not disclose confidential information, trade secrets of the company with any third party without explicit permission of the authorized person of the company. Let's say if you are engaged in the company, or you as an employee, in that case, you must not disclose any information without authorization to any third party, right? Then one need to adhere to the company policies like information security policy that includes trade secret policies, for example, what to share with any third party through electronic mode. So most of the companies, they have their information security policies, and for startups and MSMEs who don't have it, they should get one, so that the employees have a clear cut idea, because it depends upon the companies to ensure that their employees are well aware of the implications of unauthorized trade secret disclosures, what trade secrets mean, and what can be the implication, and what do's and don'ts they have to follow. So these kind of policies should be there, and there has the individual stakeholders should follow internal controls and processes in place to protect trade secret or CI. One should identify information that is confidential or in the nature of trade secret and make an informed decision while disclosing the same on need-to-know basis. I mean, not all sort of information should be disclosed to any third parties or including employees. One must make an informed decision what kind of an information is required for a particular kind of an employee or an employee in a particular department. Only those information should be shared with them. And if an information is confidential, the other side or the employee should be made aware of the fact that this particular kind of an information is confidential in nature. Also, when it comes to when any employee exit from the company, the employee should be reminded of his or her obligation with respect to the company's trade secrets or confidential information. The NDAs which the company generally use, we have seen from my experience, I have seen that a lot of companies or even startups, we see the NDAs which they use, right? They just get the template for anywhere and they just use that particular template without going into the finer details of that NDAs, which will suit their businesses. So it's very important that all sort of agreements which the companies, adhere to or look into while dealing or conducting their business, be it employment agreements or non-disclosure agreements, right? So these agreement should be carefully vetted. It should be carefully drafted in terms of facts of specific cases, and accordingly it has to be executed. Right? This particular practice of using these of templates, that is something which should be avoided in order to ensure that your trade secrets are adequately protected. Also the employees should be made aware of the trade secret breach protection mechanisms, right? So in case of any breach, what are the steps they should follow? So there should be a clear, trade secret policy which should be there in place when it comes to startups, and they should ensure that their employees are made aware of it, and they adhere to the requirements under those policies. That's all from my side. Thank you. Over to you, Nakul.
Thank you. Again, great insights. Very, very useful one. I think the contract with employees, I think, very important. I heard one case in which one of the startups, they relied upon AI generated agreement, and I think it didn't really cover the way it should have. So very important aspect. And then thank you for highlighting that. So let's quickly look at the comments and questions. I think first of all, a lot of good feedback on the session. So very informative session, and I'm very happy to see that the discussion was found useful. So let's pick up the first question from Ravi Kumar. He says, AI can automate patent type work like PatSnap or other AI tools. Ravi, I'm not very clear about your question, but I'm assuming you are asking if AI can automate the work that PatSnap or other AI tools are doing. Is that true? Or maybe you can retype your question with some more clarity. There are tools which are emerging in this space, which some of the vendors claim that they can draft it, or they can find out some sort of infringement, or they could do some FTOs, but I would say they're not there yet wherein you can fully rely on it. This can give you an initial set of results that you can look at as an expert, but I don't think it's advisable at all to rely just on that. So, but if you could clarify your question a bit, we can definitely see if there is a better answer to that. The next question is from Naveen Bhatnagar. He says, what happens to a company or LLP whose trade secrets in the form of IPR rights are stuck in a strike off a company LLP under the Companies Act, LLP Act? Does it under doctrine of bona vacantia under Article 296 of Constitution of India vest with the Government of India in the interim until restored, revived by NCLT? Your thoughts will be useful for the learned audience, please. So what happens to a company whose trade secrets in the form of IP are stuck in strike off a company?
So I think, Nathan, it's more related to the Companies Act, and I think we are not the expert here.
Okay.
But as far as I understand it, it will be treated like any other intangible assets during the
Yeah.
strike-off process or till the time the right ownership of the organization or the company is determined.
Yeah, I would agree to that. Yeah, thanks. Okay, is there any rights given whoever maintaining trade secret to take action if in case any infringement kind of issue happened? How trade secret is more beneficial over other laws like patent or trademark? So the first part of the question is there any rights given whomsoever maintaining trade secrets to take action if in case any infringement kind of issue happens?
So trade secret is not something which you go and start enforcing outright, like patents. Typically, the patents and design numbers you have to indicate on your products or the things which you are putting in public. Like for example, Coca-Cola don't put on their bottles that they have this drink is made by a formula which is protected by trade secret and so on. So you have to establish that there is a breach, and the breach happened due to the violation of the contract. The information is procured under a contract, and then it was misused. Um, that's what I feel. But Satyendra can add, or Nitin, if you want to add to that bit.
No, I think that's absolutely right. I think you have to follow the guidelines which has been mentioned by Mr. Fazal and Satyam. I think if you are able to protect it properly, then you can claim that hey, it was a trade secret, and if you are able to prove that it was acquired by unfair means from you, then you can go and assert that. So I think there is prerequisite steps to be done by you before you can go out and protect it. So
Yeah, just to add on, Nitin, when it comes to a violation of trade secrets, one difference between let's say the talking about trademark law, patent law is the concept of right in rem and right in person. While for trademark infringement, you can go ahead and sue in case you find any infringing activities. When it comes to trade secrets, the duty of confidentiality is something which binds a particular person, right? For who's responsible if there is any unauthorized kind of a leak of the confidential information, and you can show that this information was shared with this party, and this party has kind of leaked it out in the public. In that way, you can go ahead and initiate action for a breach of contract. So that's a key difference here.
thanks. And the next part of the question is how trade secret is more beneficial over other laws like patent and trademark.
So the most important aspect is that you can extend the protection beyond 20 years. That is one. The second is that once you disclose the information in public, or if someone um, uh, once you file the patent, it's you are voluntarily disclosing the information in public domain, and then that information became public, and anybody has access to that information. So if somebody accesses that information without where you have not filed a patent protection, then you will not be able to stop them from using it. I think that are the major areas. And the third thing which I feel is that once you file a patent, you disclose the information in public domain, and hence it is open to experimentation. People can experiment, come up with an improved solution or improved product, and may result into an advanced technology or which may lead to making obsolete your product in the public domain. Wherever, if you keep it secret with you, it's very difficult for people to come up with that same solution or replicate that solution. But it's other way around also. If somebody can experiment and can develop the same solution without taking information from you, then there's no protection.
Yeah.
So it goes both ways.
Sure. Thank you. Yeah, and I think if you compare with trademark, I think they are very different because they protect a different subject matter altogether, right? So
Right.
one of the ways to look at it is that what subject matter is protected by each of these IP protection mechanisms. Patents protects ideas, primarily technical ideas, falling in the domain which are not excluded by the Section 3, right? So of the Patent Act. So that's one way to look at it as well, right? So trademarks very different. You can't compare it with trade secrets. They protect totally different, uh, intellectual property assets. Okay. Then we go to the next one. Will non-disclosure agreements affect upon trade secrets in terms of revelation, non-revelation?
I don't get the question, but I think it will not work because if something is divine, uh, I don't think how you are going to protect it because it has to have some business aspect related to it. If it has, unless you have a business aspect related to it, I don't think it is going to protect by an NDA.
Yeah. And the other way to look at it is also like if you are disclosing something with the partner, which is absolutely critical for you to take it out in the market, then of course your non-disclosure agreements has to be very tight and strict, saying that, hey, this is only to be used for XYZ purpose and nothing beyond. And later, if that's found to be, used for other purpose, or the information is leaked for other business activities, which is detrimental to the owner, then yes, I think that non-disclosure agreement will be a crucial evidence to say that, hey, this is a protected information and was very restrictively shared with the other party. So maybe that's, one aspect.
Right.
Think we go to the next one then. If in a patent prosecution, the controller insists on a very deep disclosure, can the applicant agent refuse under the pretext of trade secrets? Interesting question.
So as per Patent Act, you need to disclose the information to the extent that if somebody wanted to reproduce it without doing undue experimentation, so you have to, you must, I mean, you have to disclose that. You can't deny that information. So I think taking a plea that, there's a trade secret is not going to work unless you show that this information is not required for the working of this particular invention.
Thank you. If it's a product and some implementation processes with patent, how to safeguard it? It's a product and some implementation processes with patent, how to safeguard? I guess the answer is given in the previous question itself, that hey, if it is not essential to make the patent work, then you can keep it as a trade secret and retain it, right? But if it becomes an essential information for a patent to be worked, then it must be disclosed in the patent application. So I guess that you will need to decide accordingly based on what type of implementation process are we talking about. So any other thoughts, Basil and Satyam?
I agree with you, Nitin, I think.
Okay. Then we go to the, I think we may go, it's 4:30, we are almost at the top of the hour, so maybe one more question. Regarding skills acquired by the employee, what if the skills acquired by the employee were using the employer's confidential information? Then should it not be classified as trade secret?
No, we don't think so, because see, any what trade secret has to be there, that has to be particularly and specifically identified. Skills cannot be termed as trade secrets. So these are two different things.
Okay.
Because while working at an organization, and if the job requires so, that particular person is bound to come across trade secrets, right? So the obligation upon him is not to disclose those trade secrets somewhere else. As far as skills are concerned, that's something which cannot be deemed as a trade secret. That's a different thing, and that's how the courts have interpreted it.
Right. Thank you.
A simple example to this is, if it's like presentation. A person employee may know how to create a presentation. That's a skill. But if they copy a slide or a template which was already there in a previous organization, then that would be the breach of contract. In a very simple words.
Right. Okay, I guess we do have a few more questions, but I would say thanks again for sharing wonderful insights. I think looking at the comments, we definitely feel that this was very useful. So thank you, Fazal, and thank you, Satyam, for good insights. And hopefully the attendees have also found it useful. And with that, I would like to close this session. Once again, thank you everyone for participating through the questions as well as through the presentation. So thank you and look forward to interact with you again soon.
Thank you, Nitin.
It was a pleasure being here. Thank you.
Okay.